In 1733, a publisher of a weekly newspaper in New York, the New York Post, the publisher was named Peter Zenger, wrote a series of columns criticizing the governor of New York. He claimed he was corrupt. He claimed the governor was in cahoots with the French, a foreign government. He claimed the governor was an idiot. The governor, through his appointed judge, had Zenger charged with libel. And in 1733, the crime of libel, it was a crime. There was no, if you made a defamatory statement, you were liable. Truth was not a defense. So the judge was convinced that a jury, anyone, had no choice but to find Zenger guilty. A jury was assembled. A lawyer named Andrew Hamilton from Philadelphia, who was one of the most prominent trial lawyers in the colonies at the time, stepped forward and defended Zenger. During the trial, in closing argument, Hamilton argued that while Zenger had admitted having published these defamatory statements, the jury should acquit him because it just wasn't in the interest of liberty and justice to convict him for speaking the truth. The jury went out, deliberated for 10 minutes, returned a not guilty verdict. And instantaneously, word of this trial spread through the colonies. Zenger and his lawyer Hamilton became celebrities. The Zenger trial was on the minds of the founding fathers who met in Philadelphia to draft the Declaration of Independence, the Constitution, and our Bill of Rights. The only right in those documents that's mentioned 5 times is the right to a jury trial. It's in the Declaration of Independence, it appears in the Constitution, and 3 of the Bill of Rights. It was an important, as the Founding Fathers said in the Federalist Papers, the only way to assure that we would have freedom of press, freedom of speech, freedom from unreasonable searches and seizures, other constitutional rights, was a jury would stand between the average citizen and an overreaching government that was looking to take his liberty or property away. We have come a long way from the Peter Zenger trial and the deliberations about our constitutional documents to the movie, the documentary you just saw, which is obviously a parody of what jury duty is like today. It has been a history to over 250 years of the judicial judges trying to usurp power that initially belonged to jurors. The jurors at the time of the Constitution were to decide the facts and the law. The judges have changed that. As you know, jurors can only decide the facts. The judge is very concerned about what jurors can hear. As this professor said, if you knew anything about the case, you can't serve on a jury. That was turning what the Founding Fathers had in mind about jury trials on its head. So we have a very crippled institution that our Founding Fathers thought would be a bulwark of defense against a strong central government that has been eviscerated and on our watch. We as lawyers have let this happen, and judges have let this happen. And I think it's important to remind the public and remind each other that we are living in a time where there is a daily constitutional crisis. We have a man who's the President of the United States who has declared war on the media, on the press, who wants to change the libel laws so you can sue the press easier if they say something bad about you, and who has even suggested amending the First Amendment to restrict freedom of press and freedom of speech. Fortunately, no one can rig a jury. And that's the one thing we have left, and the one thing that people on the right and on the left can agree on is an institution that before we let it go the way of powdered wigs and say adios, we ought to ask the questions I posed in the title. Do we care about the vanishing jury? And if so, what can we do about it? I began practicing trial law 50 years ago in Houston, during the golden age of trial lawyers. At the time, the three of the biggest law firms in the world were located in Houston. On any list of the 10 best trial lawyers in the country, there were always 6 or 7 Texans listed. It was trial lawyers' paradise. Today, those law firms exist, but they are no longer part of the biggest by any stretch of the imagination. None of them have trial departments. And Texas no longer has a monopoly on good trial lawyers. It has changed. I was thinking as I get older that I would be teaching trial advocacy at some law school. But then I came to the realization that that'd be like teaching dinosaur hunting. Who wants to really, there are a lot of anxious law students that would like to learn trial advocacy skills, but how can we fairly promise them that they will learn it in a day when there's so few trials? So I began thinking maybe I ought to change what I'm going to do in my golden years from teaching trial advocacy to going around the country and trying to save the trials. I began working through various bar organizations, but I realized that that was not going to work out, primarily because lawyers like you come together once or twice. If you're members of a bar association, I was active in the American Board of Trial Advocates. I still am, co-chair of their Save Our Juries Committee. But these are busy practicing lawyers that come together once or twice a year at exotic places. On Friday, they're anxious to do something to save the juries. On Saturday, they're worried about their tea times. And on Sunday, they're thinking about catching a plane home. And then you don't see them for another 4 months. So I came to the realization that if we were going to save the juries, there had to be some concerted effort. There was no academic center in the country associated with the law school that was studying the civil jury trial. And I persuaded my wife to join me in funding a project at NYU Law School in New York, and I am the executive director of that project. I'm devoting about 50% of my time. I'm still trying cases and running a law firm, both for my New York office and my Houston office. But what I've been doing for the last year and a half is working on the civil jury project and going around the country and trying to figure out what is happening to trials. Now, when you go around the country and ask the question, there is no doubt that the number of trials is declining. The statistics are easily available in federal court. I have every reason to believe that the state court statistics parallel the federal ones. But this is the story. It's a long period of time, from 1962 to 2016. I graduated college in 1962. So in 1962, the red line indicates cases, the percentage of cases, of all cases that were terminated in a year, the percentage that were terminated through a trial. So it takes into account fluctuations in filing, explosions of litigation, all that's taken into account. It really distinguishes between, the red line shows that, for example, in 62, 5.5% of cases terminated were terminated by jury trials, 6% were terminated by bench trials, and the balance were terminated by dismissals, motions for summary judgment, dismissals as a result of settlements, the plaintiff just abandoning the case. But a healthy 11% were terminated by trials. And look at the trend line. Last year, in the fiscal year ended September 30th, 1930, it shows that the percent of cases terminated by jury trials was somewhere about 0.7%. And something which I never knew before until I began getting into this, I would have called my center, my project, the Civil Trial Project, because I thought only jury trials were disappearing, that people were electing to have bench trials rather than jury trials. Wrong. Bench trials have gone down faster than jury trials. And if someone tells you, well, jury trials are disappearing because people don't trust juries, because jury trials are too expensive, take too much time, that's ridiculous. You can't, those things do not explain why bench trials are disappearing. So if you want to know and I got this morning from the statistics that are made available through the federal court. And this is in 2000, and I'll show you the next slide, which is this is a slide that shows the number of cases tried per judgeship. And you can see that it too, jury and bench, has fallen, although there appears to be an uptick in the early 80s. That may be explained simply because of vacancies on the bench or the addition of judges. But the average, nationwide, the average judge tries about 3 jury cases a year. The average federal judge, civil jury cases, and about 1 bench trial. But then I have, because it was important to us to find out, is there a variation among the districts? And what we found out that, for example, your district here in Kansas, in 2015, 2.5%, each judge here tried on average 2.5 jury trials, civil jury trials, and 0.7 bench trials, ranking Kansas as the 28th most or least productive district in the country. For the most recent fiscal year, the one ended September 30th, 2016, Kansas was down to 2.2 trials, civil trials per judgeship, and 0 bench trials. Now, how people can ranking Kansas as 38th in the country, how people who have the title judges can call themselves trial judges when they try so few cases is totally a mystery to me. But those are the figures, and you go around the country, and I have talked to judges, and no one quarrels with these statistics, but everyone has a different explanation of why this is happening. Of course, no one knows the trend is down. Will trials disappear? I don't think they will ever disappear. But I think they are becoming like the California condor, in danger of extinction. You never see them very much. No one knows how to try cases very much anymore, certainly not before a jury. And there is a danger. We are at a tipping point where unless the people in this room and the people in this district and the people all over the country who are in the trial business do something about this, we are going to lose the public dispute resolution in this country completely. It's all being privatized. It'd be like having schools in this country, all private schools, no public schools. Sure, there's a role for private dispute resolution, and by that I mean arbitration, jams, and AAA. But do we want that exclusively? If we did, it would be the end of stare decisis. There would be no precedent because arbitrations are done in confidence. No one knows what the results are. There are no law books to look at. There's nothing to guide business as to what the public thinks about conduct they might engage in. I don't think it's a good idea to allow trials to stand in danger of being extinct. So the question then becomes, why is this happening? Why do you see this trend line? And there are almost as many explanations as there are judges or trials. One that is rarely mentioned, by the way, is the public's ignorance of the fact that trials are disappearing. You talk to people who are not lawyers and you tell them we're losing trials in this country. They say, are you crazy? And the average person, non-lawyer person, thinks there's a litigation explosion. They watch on TV and the movies episodes of trials. They watch Bull, the recent series that's on right now every Tuesday night about Dr. Bull, the jury consultant. And they think, there's no shortage of trials. So one thing to do immediately is to get the word out to people that this is happening. And the way to do that, and the way we are going to do it, is simply take a cameraman with a camera to the federal courthouses across this country and take film of what's going on in their hallways on a Wednesday afternoon, a Monday afternoon, a Thursday afternoon. They're empty. Most federal courthouses in this country have become marble mausoleums. Sure, the judges and their law clerks are working back in the chambers, but the lights in the courtrooms are obviously not on. And there's no one walking the halls like there used to be. And the same pattern repeats itself in state courts. And why Congress is appropriating money for courthouses and money for judgeships when a pattern like this exists is beyond me. And we have documentary filmmakers who are interested in telling a story that needs to be told. Another reason, big reason, why trials are in danger is that in the 80s, early 80s, with the election of Ronald Reagan, big business started the lawsuit abuse movement that ended up giving us tort reform, medical malreform, securities law reform, antitrust reform, class action reform, and today, and repeatedly, patent reform. So, and all these reform meetings are they're just labels, mask for let's limit the type of claims an injured party can bring in court. That's all it's about. And it's moved from substantive area to substantive area. And something that the Chamber of Commerce, the Business Roundtable, found to be very helpful to them. And by the way, you'll see one thing that's striking about this chart is while there seemed to be an uptick in jury trials in the 80s, something happened in 1986 that made it, the floor fell out. What was that? 1986 was the year the Supreme Court decided its summary judgment trilogy, which makes it very easy for defendants to get summary judgment. The judge simply rules that your evidence is not plausible enough to go to a jury. And since that was the year, coincidentally, the American Tort Reform Association was established in Washington, D.C. And part of their modus operandi was convince the public that juries cannot be trusted. Not only do we have to restrict the causes of action and the kinds of claims a person can make for securities fraud or antitrust collusion or patent infringement, but we have to cast doubt on the ability of those who are going to be deciding the case. We have to cast doubt on their ability to be trusted. And that's what that movie, which was made by the Defense Research Institute, that first thing you saw was all about. You know, that is a real indictment of the jury. If you think that that's what a jury trial is about, who would trust their civil dispute to resolution by a jury? So, and we had this attack with the coffee case, runaway juries. So that has been another thing that has caused the line to go down. I asked a federal judge, when I began this project, I asked a federal judge in New York, why is the Supreme Court so hostile to jury trials? And he said, well, you know, there were 9 justices in. He said of the 9 justices, only one has ever tried a jury case, Justice Sotomayor. The others have not tried. They are scared of juries. They don't see juries operate day in and day out. They see the outliers, the runaway verdicts, the extremes. And therefore, they think that, listen, it's not fair to make a business, a company, have to bet the company at a jury trial. So let's begin creating, and this was never done explicitly, although some opinions come pretty damn close to being explicit. Let's create a system of gates that a plaintiff's lawyer representing an injured party has to get through before you get the opportunity to present a case to a jury. Enhanced pleading, that was gate number 1. Twombly, Iqbal. If you don't plead a case that's plausible, you don't advance to the next stage. And then you have the summary judgment trilogy. And then Daubert. If the judge doesn't think your expert is reliable, and when I began practicing law, reliability was a question for the jury. Now it's a question the judge decides, is the testimony reliable? If he decides it's not reliable, it doesn't go to a jury. Class actions, it wasn't too many years ago where the jurisprudence was, if you're going to, in ruling on whether a case should be certified a class, err on the side of certifying as a class. You can always decertify it. Class action certification does not involve a decision on the merits. Law's been turned upside down on that because too many cases were being certified. So now it's difficult to get a case certified. And you have to go through a mini trial on the merits to get it certified. Motions in limine practice, which you have to go through for days and days before you can submit a case to a jury in most jurisdictions, is just another way of allowing the judge to screen what the jury is going to hear. And if jury, I do believe that there is jury cases are more expensive than non-jury cases not because of discovery, the discovery's the same, but because in a jury case you have to get through all these hurdles, get through all these gates or screens before you can even present your case to a jury. And then we had, at the end of the 90s, mediation became a big deal. Joe Biden, when he was a senator, a Democrat, gave us that innovation. Mandatory mediation. You got to mediate the case before you get a trial, which is the rule in most districts and in most forums. And finally, the Supreme Court discovered the old 1920s New York Arbitration Act and ruled that the Arbitration Act trumped any Seventh Amendment right to a jury trial. If you even whisper or touch an agreement that requires arbitration, you are bound to arbitrate your claim, and the arbitration agreement can include a denial of your right to assert a class action, which in many consumer cases means you can't vindicate your rights at all. But the court fell in love with arbitration, and that's one of the reasons that cases don't get tried is that they are forced into arbitration. Congested budgets, congested dockets, budget restraints, created a generation of judges, some of whom may be in this room right now, where the metric of performance was how well you cleaned up your docket. How many cases did you dispose of and how quickly? Not how long you were sitting on the bench watching some dumb lawyer like Steve Susman try to persuade a jury that his client deserved millions of dollars, but how you got rid of the backlog. And there are even judges in the country today that will tell you frankly, I'm trying to embarrass them about this, by the way, but they will tell you that if I have to try a case, I failed. Just imagine it. how can we hope to save trials if judges have that mindset? And of course, there are corporate clients, big companies do fear juries, and rightly so, because as that movie indicated, judges have been very clever about denying to jurors the tools that the judges have to decide cases. I'm a great believer that 12 minds are better than one, that 12 jurors can decide a case much better than one judge. If they are given the tools, the ability to take notes, the ability to ask questions, the ability to discuss the evidence before final deliberations, a copy of the instructions written in plain English, where every juror has his own written copy and a copy of the verdict form. We need to do a better job instilling in the public, and the consuming, by that I mean not really public, the business community, the general counsel of this country, the idea that jurors can be trusted, and we need to do a better job by giving the jurors tools they need to decide a case in a predictable way. So, and then we have a consequence of all this, and judges will tell me, say, I've in the last year and a half, I've gone around the country and met with hundreds of judges. We have 165 judges, state and federal, who are actually advisors of the Civil Jury Project. And I hope some in this district will join us as advisors. It just means that you get our newsletters monthly, and we get your feedback and your ideas about what we can do to stop the disappearance of jury trials. But in talking to these judges, they will say, you know, I'd love to try more cases, but I can't get lawyers who will do it. The lawyers don't know how to try jury cases anymore. You know, we have a generation of litigators, not trial lawyers, and they're scared, and you know, they fold like a cheap tent on the eve of trial. They settle. The plaintiff's lawyer's happy to just get a mediator to force a settlement and take their cut of the third and put it in the bank. They don't care where they go to trial. And so no one's really there pressing to have a jury trial. We wish we could get more. So in any event, we have a long list of reasons for what we are seeing here. And my position has, I've come to the conclusion that if I try to figure out what the real reason is, I'll be dead and the project will be long gone before I get to the answer. I've got to begin assuming that all of these have valid reasons, and what do we have power to do something about. The tort reform, lawsuit abuse movement, I don't have the funds for that. I'm part of an educational institution. It would be improper for us to do it out of NYU Law School. And so I've got to leave that to the bar groups, which have done a miserable job in protecting the right to jury trial. Here are the kinds of things we are trying to do. We have become, in the last few weeks, extremely active. The Civil Jury Project. I'm doing this, I'm the executive. I have a young man who just finished clerking for the Sixth Circuit, who's a research fellow at NYU and an administrative assistant. There are three of us working full-time, almost full-time. For me, it's about 60% of my time on this project. So one of the things we are doing is now beginning, I have a beautiful website called the Civil Jury Project at NYU. You can Google it and go there and look. It's meant for judges and lawyers and jury consultants. But it's not public friendly. It's not juror friendly. It's an academic thing. I need to figure out how to talk to people who serve on juries. There's a disconnect out there in the community. People who serve on juries, 100% that I have talked to, and I've talked to a lot of former jurors, love the experience. It was the most rewarding experience in their life. They would love to do it again. People who are summoned and not selected hate the experience. They go down there, they waste their time, they are subject to invasive, privacy invading voir dire. In some jurisdictions, it's not even judicially supervised. It goes on in a 2-day trial. You can spend 2 weeks sitting there before you are excused because you've got 2 judges and you're in a conference room. This is true in New York state courts and Connecticut state courts. And I don't know about your Kansas state courts. I'm not familiar with Kansas state practice. But it's certainly, and then you have a third group of people who have received jury summons, haven't reported, and all they're doing is searching the web to see how to get out of jury duty. And if you Google jury duty on YouTube, if you put in jury duty, that's what you'll see, a bunch of comic things, Saturday Night Live skits about what you say to avoid jury duty. So our notion was, wouldn't it be great if we could put together the people who have actually served with the people who have received their summons and looking for a way to get out, and have them talking to each other. So the ones who have served would say, don't get out of this. You are giving up an experience of citizenship of a lifetime. We have begun to do that. We have created a public-facing website called WeThePeopleWeTheJury.com that is designed and we have a presence on social media with the hashtag Jury Matters. And we are getting a lot of followers and a lot of interest. And hopefully, our most recent, today we are tweeting. We are following President Trump's example about developments. We are tweeting about Neil Gorsuch. Neil Gorsuch, I've been working on this since last night with my research assistant, has said some very nice things about jury trials and us needing more jury trials. Not only that, when he was practicing law with Kellogg Huber in Washington, D.C., he tried the antitrust case representing the plaintiff that resulted in the largest verdict in the history of antitrust cases. So he's a man. We have now a second Supreme Court justice who has actually tried a jury case. So whatever you think about him on the social issues, and so we need those who think he's clearly qualified. So whatever you think about on the social issues, apparently he's going to be pretty good for us on civil justice issues. And then, of course, every group that's fighting mandatory arbitration has been sending hot emails all day because he's pretty good on that too. In the one case where he talked about arbitration, he said, the judge first, you have to have a trial to first determine whether both parties, in fact, are contractually bound, whether there was a meeting of the mind, an agreement to arbitrate. Many courts are skipping over that step and saying, well, that's for the arbitrator to decide. And of course, that was a helpful, everyone's reading the tea leaves about where he's going to come out on these issues that are important to trial lawyers around the country. Another thing we have done and are doing as a project is to study why lawyers who try cases think trials are vanishing. We have partnered with this, and I've never seen the lawyers, this is a partnership that you will never hear about because it was my idea. Who has a big stake in saving trials as we do? The trial consultants, the jury consultants. It's an industry. They have a trade association, American Society of Trial Consultants. And they are now partners with us and working with us. And they are great because they are used to doing empirical research. They can assure judges, one of the biggest innovations that we are suggesting to judges, the simplest one of all, in addition to asking questions and all these other things, short trials. Trials where each side gets 2 days. You get a day in court, not a week in court or a month in court. And where you each get 10 hours to put on your case. Can it be done? The Eastern District of Texas is the most complicated patent cases known to man. Gives each side 15 hours. Period. The case is tried in 5 days. The damage model frequently exceeds $150, $200 million. And yet lawyers on both sides of that document, we put on a conference at NYU, the trial of patent cases, jury trial of patent cases. And the judges who came and the lawyers who were there all thought that one of the biggest innovations is to limit the time. It doesn't affect the results at all. You can get the same result. And the jury consultants who will mock try a case in a day will tell you that they can get the same result. They can tell you reliably who's going to win the case after they do it. So we have commissioned and done a study of 1,000 trial lawyers around the country, and that results is going to be published within a few weeks. We have conducted empirical research by examining reading. The academics at Baylor Law School did this for us. Every material contract filed with an 8K by a public company during the first 6 months of the year to find out how many of those contracts, and a company's required, a public company, to file a material contract, how many of those contracts have a jury waiver? How many have a mandatory arbitration clause? I was shocked to learn that less than 50% have a jury. More than 50% of the contracts are not disavowing civil trial by jury. So the idea is, really, what are those general counsel thinking? So now we're locating the general counsel who are opting for jury trials or judge trials, but not waivers or mandatory arbitration, saying, why are you doing this? What do you think? Because we have got to make this sellable to the consumers. So that's another project we are doing. We have written articles on all the innovations, and we're getting the judges, of the 160 judges that we have as advisors, to use their courtrooms trying these things, trying jury question, allowing the juries to ask questions. It's an innovation that everyone likes. Allowing the lawyers to make short interim argument. Experimenting with all kinds of new ways of presenting evidence. I mean, presenting the jurors. Each juror gets an iPad, not connected to the internet, but connected to a court's wireless, so that when you come in, it's not theirs to take home, but when they come in, loaded on the iPad are preliminary substantive instructions, a cast of characters, a timeline, a glossary of terms, every key document. And not only that, the testimony, when it's transcribed real time, the lawyers are seeing it on their screen, the judges are seeing it on their screen, the jurors will see it on their iPads too, because some people learn better if they can read. Well, why aren't we doing that? We give students iPads. Why aren't we giving jurors the iPads? In any event, I am about out of time, and we're doing a lot more. And I came here basically, I want to talk to groups like you around the country because we need your help. We need you to talk up this issue. We need you to talk to judges, to tell them that you can try more cases if you will get fixed settings and limit the time. We're not going to be mad at you for limiting the time. Every time a judge limits me in the amount of time, I moan and groan, and then I try the best case that I've ever tried, because I had to eliminate nonsense and go for what's essential. And so we need the cooperation of the bar and the bench to get this done. And hopefully we will, at the end of it all, come to the conclusion that it was a good thing that we retained civil jury trials. Our founders were not wrong. They were right. They were right that a jury is like a fourth branch of government, that is a checks and balance on what judges do, and that we need to restore the public's faith in juries and to make them a better truth finder than they currently are. So thank you. I've run out. If there are any questions, I think I've just run out of time, period. No questions. But if you have any, I'll be around. You can ask me questions while I'm around. you get in touch with me and go to the website or call me or anything. Thank you very much.